I salute you all. Thanks for being on and thanks for watching. So probably today we are under the foundations of law, which probably may mean as the introduction to law as a course unit basically. And today we are looking at its introduction, the definition basically, its purpose or the importance of law in the community. You get? So basically here what you have to know or what you have to bear in mind is that this course unit is among the easiest course units. Basically for you it is a matter of understanding something and you reach on paper and you write how you understand it. It is not all that most of cramming, but you have to understand because this is the introduction, the foundations of the law, that the law that we study up there or we study in the different course units. So basically we are looking at its definition, the definitions of the foundations of law. Sorry, the definition of law. Basically in the layman's understanding, we can define law to mean the set of rules or a body of rules and principles, rules or principles that control human conduct basically helping in the administration of what? Of justice. That is the dictionary definition that I can give about law, because there's no any statutes that defines what is law, basically. And here what you have to bear in mind or what you have to put in mind, however much that is not the conclusive or something that is the authoritative definition of law, we shall see how various scholars have defined law, because each scholar has a different view of thought on the definition of law. And basically some of the advantages or the purposes of law: protect human dignity, to promote rights, to protect human dignity, to create really order in the community, to defend the rights of people, to promote a good governance, to bring easy administration, to bring rules that are conformity with the principles of humanity, among others. Those are some of the purposes of law that I can give, or some of the importances of law that I can give basically. But we are going to look at the different definitions. How are the different scholars defining law? You can realize that however much law, there are a set of rules as you have defined, but however each scholar has a different point of view to mean what law means basically. So here we are going to look at one of the scholars. There are various scholars, but we shall look around a few of them among the various scholars that are around the globe. And more so realize that for us, we just adopted the law, which means in the scholars we don't have any Ugandan scholar that defined the law, since we just adopted the white man's rule or the white man's what? Norms. We shall, first of all, there is a scholar called Marcus Tullius Cicero. Marcus Tullius Cicero was that time of 106 BC before Christ to 40 was in the era of 106 BC. This Marcus Tullius Cicero, for him he was a Roman philosopher. Politician, lawyer, orator, political theorist, among others. Basically, that's one of the history about him. So this man was a naturalist, was from the natural school of thought. As you shall see, the theories in law was from the natural school of thought. But he was greatly inspired, or he inspired greatly in the writings of Plato, Aristotle, among others. You get? For him, his point of view, how he defines law to mean that it is the right reason in agreement with nature. You understand? Basically, for him, he said that it is the right reason in agreement with nature. For him, that's how he defines law. Basically, that's how he defines law. Basically, it's like a universal application on the unchanging and the everlasting what? Society. Basically, for him, that's how he defined law, to mean law. That is Marcus Tullius Cicero. Then another scholar or philosopher that we have, there is Saint Thomas Aquinas. For him, he was from 1225 to 1275. That's the time frame he existed. This Thomas Aquinas was an Italian priest of the Demarchian what? Order. Remember, was a priest. When you remember very well the history, the church was more so influential in the what? In the political arena of the country. More so in France, Italy, England, the church was mostly influential. So this Saint Thomas Aquinas was an Italian priest, you get, and he was also on the norms of the what? Of the natural law, or the school of the natural theory, you get. And how can I say, was like a proponent of the natural law. He wrote the book which was known as the Summa Theories, or the Summa Theologica. That was the book that he wrote. And for him, under this book, he defined that law is categorized in various ways. You have the internal law, the divine law, the natural law, and the human law. You get. Also, we shall see more details when you go to the theories, most of the natural school of what? Thought, to see these categories: internal, divine, and natural, and human. You get. All those were the categories. That's how for him he identified what? He described law, or he defined law. So another one, you have John Austin. John Austin was from the year of 1790 to 1859. That was John Austin. And basically, John Austin was a British jurist, a publisher of the philosophy of law and jurisprudence. He served in the British Army. John Austin served in the British Army in Sicily and Malta. But however, he sold his office as what? Commission to study law. When he studied law, for him he was best known for developing the theory of the legal positivism, the positive school of what? Of thought. That's the idea that he developed. You get. And for him, he defined law that it is a command. Basically, for him, he said that the law is a command and a sanction by the sovereign. For him, that's how we define law, as precise as like that. That was John Austin. Then we have Professor Hans Kelsen. He served around from 1881 to 1973. That is Professor Hans Kelsen. He's well known from the Hans Kelsen theory of thought. This Hans Kelsen was a German philosopher, or a German scholar, a legal philosopher, and a political philosopher. Was a politician, was a philosopher, and was a German scholar. He was known, actually for him he was known of his magnum opus of the pure theory of law. The pure theory of law. We shall see these theories more so in the theories themselves. Was known for the pure theory of law, and for him he defined law as a hierarchy of norms, which are also binding norms. For him, he says that the validity of each norm is resting upon the higher norm. Basically, he made some statement that the legal order follows the legal norm. You get? It's like saying that the law to come in, it must be in conformity with the what? With the norms that are in place. The norms, those are the behaviors of the people. You get? That's Professor Hans Kelsen. So we have also Nathan Roskpound. This Nathan Roskpound was born in the year of 1870 where he died in 1964, and he was an American legal scholar. And and he was like an American legal scholar, and he was an educator. He was like a teacher, basically. There's a book he wrote that he wrote The Spirit of Common Law, or The Law Norm. That's the book that he wrote, and he was composed of the founder of the sociological school of thought, the sociological school of thought. And basically, for him, his idea was on the historical movement of the law and justice in their relentless contemporary constructions. For him, that's how he speculated to define law. You get. Then there is also another scholar who is Karl Maximilian Weber. He was born in the year 1864 to the year 1920. That is Karl Maximilian Weber. Basically, this man was a German sociologist. A philosopher, a politician, and an economist, basically. And for him, he defined law as a domination within a society. He defined law to mean that it is not a domination within a society, or not attributed to the people, but to the abstract form. For him, that's how he defined the idea of the idea of law. Then we have Emily Durkheim. Emily Durkheim was born in the year of 1858 to the year of 1917. Basically, was also from the sociological school of thought, and he was a French scholar. You get. For him, actually, he defined law that law is an indicator. That's what he says. Law is an indicator of the mode of integration of the society, which can be a mechanism among identical parts. Understand? Which can be a mechanism among identical parts. That's to do with Emily Durkheim. Then there is also the great historian who is known as Karl Marx. Karl Marx is also known for his definition of law. Those that studied European history all know Karl Marx was a politician, was a writer, was a scholar, among others. This Karl Marx was born in the year 1818 to 1883 and was a German philosopher, economist, sociologist, journalist, revolutionarist, among other titles. That was Karl Marx. For him, Karl Marx brought the Marxist theory, or the Marxist school of thought. And for him, he lamented, saying that the law is the mechanism by which one social class, usually known as the ruling class, keeps all the other classes in a disadvantaged position. They are saying, like, the ruling class, the law is the mechanism by which the ruling class keeps the other classes in a disadvantaged position. It's like the ruling class use the law to dominate the other classes. You get. So those are some of the definitions by the different scholars. So if a question comes that identify the different definitions of law, basically you just give the dictionary definition first, but again you give how each scholar is defining the different classes, or the different is giving his point of view on the definition of law, basically. But we are going to look at the theories of law. Basically, each scholar had a particular theory, you understand, point of view. So thank you for listening, and please subscribe to the channel. I wish you the best and good luck.